Institute of International Criminal Law in Uppsala, Sweden. He's the author of numerous outstanding treatises on international criminal law. Focus today, we reflect back on Nuremberg and we reflect back on Tokyo and the fact that those were ad hoc trials. They were set up specifically for certain trials. There was no permanency to it. Now, of course, we have the International Criminal Court, which has been signed by most countries, not the United States. Give us an overview, if you would, and kind of what your reflections are, what you heard, and what it might be.
Generally speaking, when we are speaking about international criminal law, you must know that there are different types of international criminal law. Because sometimes we speak about general international criminal law, sometimes we speak about particular international criminal law, sometimes we speak about universal international criminal law, and sometimes we speak about jus cogens international criminal law. But what are the differences? Because when we speak about justice, we must speak also all the parts of international law. Generally speaking, international law and international criminal law is based upon international treaties. So everything when we speak about justice, we must speak about international treaties. International treaties. Because there are different sources of international criminal law. There are international treaties, customary international law, opinions of writers, judgments of the tribunals, national tribunals and international tribunals, resolution of the United Nations General Assembly and Security Council. So we must specify which sources of international criminal law we are speaking. So generally speaking, the most important source of international criminal law is the law of treaties. The law of treaty is based upon ratification, upon signature and ratification. Signature means that we accept the treaty in international criminal law, but it is not still on force. We just signed it, negotiate it. Certain parties from the different states, different diplomats, they go to the international conference and they speak about that important matter. Then they sign it. Then it comes to the ratification. Ratification is the most important part of international criminal law. That is when we speak about justice, we speak about International Criminal Court or ICC, we speak about whether the United States government has ratified it or not. It's not a matter of signature, it's a matter of ratification. Ratifications gives force to a treaty. So all international matters must be legal. And the principle of legality is the most important phase of international criminal law. So one of the problems of which raised from the Tokyo Tribunal or Nuremberg Tribunal, it was that the question of legality was always, and it will be always, is the question of international criminal law, because it was the principle of retroactivity, the principle of ex post facto law. Ex post facto law means that the law which did not exist at that time. We didn't have crimes against peace, we didn't have crimes against humanity, we didn't have crimes against war crimes, these certain things we didn't have. But we knew something is wrong. We knew the law was violated. So we have to create it. So we knew the German they have done wrong, we knew also Japanese they have done wrong, and we know also that the United States also did wrong when the war was finished. They attacked to Hiroshima and Nagasaki, and they commit war crimes, crimes against humanity. And if you speak about the United Kingdom, also they did wrong during when war was finished. They attacked again to Germany, and they dropped certain bombs, certain cities they destroyed. So we must speak which parts of international criminal law we are speaking and which part is really justice. Generally speaking, the international law of jus cogens is the most important part of international criminal law. Because jus cogens are those norms that they are. Those rules and regulations, formations, and the conventions or charters that have to be followed by all states, regardless of their signature or ratification. This means that crimes against humanity when we speak. So you see that we have different parts of international law. So if we speak about justice, United States, suppose if you know during the Vietnam War, they commit genocide in Vietnam and violated the law of war, and it was a genocide. But they claim that they have not ratified the Genocide Convention. But the question was that Genocide Convention was an integral part of international law of jus cogens. When we speak about the international law of jus cogens, I told international law of jus cogens means that part of international criminal law that does not read ratification. It has come to that position, that universal position, that it is necessary for international morality and international human rights to be respected by all states, without due regards to their differences, to their political power, to their juridical power, or to their military power or economic power. So, if there is some question, I can go on.
Steve, why don't you say?
I'm sorry, Doctor. I was just wondering what particular word you were using.
I was wondering that jus
cogens.
Yeah. I don't know that word.
You don't know.
Yeah.
Can I write it?
Sure. Yes, go ahead.
Yes, that was the word.
It is war crimes, apartheid, slavery, genocide. They are international law of jus cogens.
So that means it's understood by everybody.
Everybody, every culture must respect it, without due regards to the ratification. This means we cannot practice apartheid in this country or another country, whether we have ratified the convention or not. This is the most important. Because, as I told, the most important part of international law, we speak about international law of jus cogens. And we speak about international law of treaties. And international law of treaties is formation of and the regulations of those rules that we think it is necessary for the respect of international human rights, for the respect of international culture, international morality. They are all together is that part of international law that we should respect it.
Yeah, what other countries beside the United States haven't signed and ratified the ICC?
Has Israel signed? Israel?
No, no. They are first. You see, when we speak about international criminal law, first we must speak about United Nations organization, about the United Nations Charter. I just tell for the example, it was 1943, you know much better than me, when they were drafting the United Nations Charter. And they have drafted, I told it was an international treaty. So representatives of Europe, when they were, it was finished, they told we will not sign it. We will not sign this treaty because it is unequal treaties. Because we cannot sign the treaty which gives the power to the Security Council. So United States representative, if you read the history, he went out. He said, okay, you don't need to sign it. Okay, I will tear it. He tear it and dropped on the floor. He went out. He told, go home and tell to your governments, no, we have no United Nations. Whether you should accept it, whether you should not accept it. He went out. So all the representatives, they ran after him. They thought, okay, come inside, we will sign it. We will sign it because it is best to have it than to don't have it. At least to start it. To start it and to see the result, hopefully in the future. But still, after 50 years, 60 years, we know still there is no balance. And the problem is, as I told, when we speak outside the country, people, is not the question of population of the United States. It's the question of the policy of the United States.
Is there hope? Will the United States...
Yes, of course there is hope. Of course there is hope. Because they changed their policy about the Genocide Convention. They are going to change it. This is the question of time limitation.
As you see what's going on in, well, without the United States being currently involved as a signator and ratifier of the International Criminal Court, do you see much precedent being created now? As, you know,
No, this without United States is not complete, because we have left the definition of aggression to the United Nations Security Council. And as you know, since 1918 up to today, we have not still a complete definition for the word aggression, for the term aggression. So it is very difficult. So if the tribunal is going to be established and is going to have a case, this case is not going to create a process as long as we have not the United States inside this process. The problem is when they established the tribunal, they didn't think that Milosevic was very strong. He has the ability to guide and to lead the population. So he is using that information that he has got. And he's using also the tribunal. And tribunal is really coming to the problem, to many problems that they are facing, and they have never thought about it. And this is also is going to be a problem that they have in Iraq, because Saddam Hussein also is very familiar with how to, the same attitude that Milosevic has. So this is also going to be a problem there also, because no judge can look at to him directly to his face, because he can just monopolize you by his eyes. So this is a problem of tribunal. We are facing that. Right. We are facing. And this is, for future, we must know how we are going to deal with this problem. And also the problem of the victims and the problem of the witness. This is a big question in international criminal law, because witnesses are not protected. We have not still no international criminal convention which is protecting witness. And witnesses, they are very afraid to come to the tribunal and to say, because he can just abuse them. Milosevic abused them directly to their face. So we have no law. This is the problems that we are facing. But we have to face it. It is good to face it and to solve the problem. International law is, you see, we have positive international law or written international law, and we have customary international criminal law. They are, so positive international law is that important part of international law, which is written international law. So when we are talking about international criminal law, we are talking mostly about written international criminal law or positive international criminal law. And concerning to your question, you see, punishment is not important. To punish Hussein, to punish Milosevic, basic from the structure, to see what is the wrong with the principle. And according to me, as long as we have not established the principle of equality, full application of the principle of equality for all the states, we have this problem in international criminal law, and international legal community is going to face this problem more and more and more. Crimes against humanity is not going to be prevented as long as we have not cultivate the principle of equality. The principle of equality means the application of international criminal law for all those who are committing international crimes, without due regards to their political, military, juridical, and economic attitudes.
What, if the United States came on board with the ICC today, or well, tomorrow because it'll be a business day, what effect would that have on the international community, and particularly the international criminal law practitioners?
It's very difficult to answer just on.
It's so wide and broad.
Yes, it's a very, very big question.
But what possible benefits and what possible detriments?
At least, I just tell you in some words, at least it has political effect. If not immediately juridical effect, legal effect, it has political effect. It means psychologically other states, they know no international criminal law, international criminal tribunal is established, and the United States is going to protect it. So this is the most important. It's just political. That's psychological effect.
When you leave here Thursday, or Friday, I forget which day you're leaving, but what is it that you want the Jackson Center and all the participants who listen to you to walk away from saying, Dr. Malekain leaves this as a message to this symposium? What would that message be?
The message is just to respect all the nations, the international legal community, the international culture, the international morality, and the principle, the full application of the principle of equality. under all the nations and also under the United Nations Charter, the authority of the United Nations Charter. Is the most important principle. If we respect the principle of equality, we have to respect other principles too.
Will you talk, that's a generality, will you talk about particularities too this week? Giving examples?
I hope so,
of what you-
I hope so.
As you look on the agenda, you have a position. Who on this panel of people that are coming here kind of has a position that might be different than yours? Kind of the opposite.
We will see. We will see. I will not tell what we will see.
Okay. Great. I know you want to do a rest before you go tonight. I just want to say thank you for coming.
Thank you very much.
It's been terrific.
Thank you.
Appreciate it.